Hello everyone, welcome to the second and final PowerPoint for this unit. This one's going to be on civil rights. So when Thomas Jefferson wrote the Declaration of Independence, he wrote this phrase, all men are created equal. And, at the time, that was obviously not true, at least not to Jefferson. It was a bit of flowery language. This is a time when not only are all men not created equal, but only white rich men could vote, and we still had slavery. So, this idea that all men are created equal in Jefferson's time is kind of laughable. And what he really meant was all rich white men are created equal, and then everybody else could just, be off to the side. Today, we have a difference in the way that we view equality. We generally believe, as a U.S. society, that people are equal politically, legally. They have an equity of opportunity, but we do not believe in equality of economy. Economic equality is something we've never really gotten to. That's not really the basis of our economic system. But generally, we have this general equality of people. The problem is that the Constitution never actually uses the word equality. It never does anything like that, which is why we needed the 14th Amendment after the Civil War to kind of spell that out. And the 14th Amendment has this one part of it, the Equal Protection Clause, which we'll talk about a lot more in a bit. And the Equal Protection Clause is really the main avenue that we get civil rights. That's really where most of these civil rights come from, because it states that states specifically can't deny equal protection of the laws, which is what ends a lot of the discriminatory action that was happening immediately following the abolishment of slavery. So when we talk about civil rights, one of the main aspects of that is segregation, and there's two main ways that society can segregate. There's de jure segregation and de facto segregation. De jure segregation is of law, so this is segregation that's happening because the law is mandating it. So this is like Jim Crow laws in the South, like having separate facilities for different races, stuff like that, like apartheid. That would be an example of legal segregation. De facto segregation is of fact, like it's happening more naturally. Social conditions just kind of create this separation. So this was pretty common in the North at the time where the South had the legal segregation and Jim Crow laws. And in the North, you saw a lot of de facto segregation, but in a lot of ways, you still see it today. If you look at different school districts or different towns that are predominantly of different races, all that would be an example of de facto segregation. It just kind of happens over time, naturally. Not illegal, so it's a different type of segregation. So the first time the court really addressed this issue of civil rights in a substantial way was in the case Dred Scott v. Sandford. And they did a really, really, really bad job of that. Dred Scott v. Sandford is a case where there was a slave, Dred Scott, who lived in Missouri, and he, for like a period of 10 years, moved to another state, I think it was Illinois, and he was living there, and then he came back, and he's living in Missouri, and he sued for his freedom, saying that because he was living in another state, a state that did not have slavery, that was illegal to have own slaves, that him and his family should be free because of that. So he takes it to the Supreme Court, and the Supreme Court hears this case, and they rule that not only is he not able to gain his freedom, but they say that any black person, whether they are a free person or a slave, are ineligible to be citizens. They just can't be citizens at all. And because of that, he can't even bring the case before a court, and they just throw it out. They say he lacks standing because he's not a citizen and therefore can't sue in federal court. So Dred Scott remains a slave, but more importantly, it sets this precedent that any black person in America cannot be citizens at all. So, and also it sets the precedent that slaves are property, and the government can't take away property from people. So overall, it was just a disaster of a ruling, and it was a disaster for any civil rights at that time. Now this is before the Civil War and before the 13th, 14th, and 15th Amendments, so that will change things. But it is going to now take a constitutional amendment to establish any sort of citizenship for any black person in the United States because of this case. So following the Civil War, the country has to kind of put this all back together, and in order to do that, they realize that they need to change the way that the government, specifically state governments, deal with black Americans, specifically former slaves and current slaves, because now the war is over, and all of a sudden there are going to be millions of freed slaves living in the South, and that's going to create a dynamic that's going to be very difficult to deal with. So they passed a series of amendments called the Civil War Amendments or Reconstruction Amendments, which are the 13th, 14th, and 15th Amendments. The 13th Amendment is pretty basic. It abolishes slavery, makes that unconstitutional. The 14th Amendment is a bit more complicated. It's got a bunch of different stuff in it, but essentially it grants everybody equal protection under the law. The Equal Protection Clause, which reverses Dred Scott, is the biggest part of the 14th Amendment in terms of the one you'll hear about the most. The Equal Protection Clause is what's used to kind of advance civil rights, and still is. And originally, this was intended to protect the rights of freed slaves, and they wanted to make sure that freed slaves were citizens of the United States and that they had the ability to participate in democracy and also not be discriminated against. And that was the idea of the 14th Amendment. And then later on, it would take on a bunch of different forms. And then the 15th Amendment says that you cannot deny somebody the right to vote based on their race, color, or former status as a slave. So this is to give voting rights to black men. This is still before women get the right to vote, so this really only applies to black men. So the 14th Amendment has several parts to it, but this is arguably the most important part and kind of the heart of what it was trying to get at. And the main part of this is the first part: all persons born or naturalized in the United States and subject to the jurisdiction thereof. So that part of it is to kind of deal with Dred Scott, that if you are born in the United States, you are then automatically a citizen and subject to all of the rights that you get as a citizen of the United States. So that means that all slaves at this point are automatically citizens because they were all born in the United States because the slave trade had been abolished so long ago. So that's part of it. Then it says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. That's the Privileges or Immunities Clause. And that one is not as relevant today because of a case that I'll talk about in a minute. But essentially what that was trying to do is the same thing as the Privileges and Immunities Clause that's already in the Constitution, but just making sure that states abide by that as well. And then the last part, no state, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So that part of it, the Due Process Clause and Equal Protection Clause, kind of, again, echo, or at least the Due Process Clause does, echoes what's in the Constitution, or the Fifth Amendment, but in this case, it's specifically saying states. So this is kind of what I've been talking about for a while. There's this problem with the Constitution, which is that it doesn't actually say that states have to follow it. It just says that the federal government has to follow it. This now makes it very clear that states also need to abide by the Bill of Rights in this whole process of due process. And then that last part, the equal protection of laws, that's going to be the clause that's used in a lot of civil rights cases and to advance civil rights in general. So an easy way to remember the main parts of the 14th Amendment is the acronym Don't Eat Peas, which I think is a particularly good one because I think peas are disgusting. So you got due process, equal protection, privileges or immunities. So the 14th Amendment is one of the most, if not the most challenged amendment in the Supreme Court, or at least the most commonly referred to one in the Supreme Court, because you have the Due Process Clause, which is pretty much going to make everything that applies to states. It's automatically going to be a due process claim. Then you also have the Equal Protection Clause, which is going to deal with a lot of civil rights programs. So any kind of civil rights case or equal protection case is going to use that part of the amendment. The Privileges or Immunities Clause is less used because the idea of it was to make sure that states were protecting all of these different rights that people get. And that they were respecting the laws of other states. That's really what the Privileges and Immunities Clause of the Constitution does. It basically says if you're a citizen of a state, then other states need to respect the things that they would give their own citizens. So like if you have a driver's license and you go from one state to another, they need to respect the driver's license. Or as a resident of New Jersey, if I wanted to buy property in Pennsylvania, I'm still allowed to do that. They can't bar me from doing that because I'm not a citizen of Pennsylvania. So that's what the Privileges and Immunities Clause meant. Privileges or immunities were supposed to do a similar thing, but dealing specifically with states. There was a series of cases, or just really one case was all grouped together called the Slaughterhouse cases, where in, I think it was Baltimore, there or some city, they basically made a monopoly where they said that only slaughterhouses could exist if they had government contracts, so that limited it dramatically in who could actually run slaughterhouses. So people sued saying that it was a violation of their privileges and immunities, that they were citizens of this state, and therefore they should be able to have the privilege of owning a slaughterhouse in the state. And the Supreme Court basically just said no, that's not applicable because this amendment wasn't meant to do that. And then since then, nobody's really used privileges or immunities clause for anything. So not as relevant as due process and equal protection. Those are really the main two parts you really need to understand and know what they do. So the Reconstruction Amendments were aimed at trying to fix this issue of what to do with freed slaves in the South, try to provide some equal rights to formerly disenfranchised people, mostly slaves. And it succeeded in some ways, but it also left a lot of big gaps in how to deal with that. So they tried to fill some of those gaps with the Civil Rights Act of 1875, which basically said that private organizations could not discriminate against people based on their race, like restaurants, businesses, stuff like that. This was eventually ruled unconstitutional because the court said that you can tell the government not to be racist and the government can't discriminate, but people can be racist and discriminate, and you can't stop them from doing that because the Bill of Rights does not apply to people, it applies to the government. Later on, with the Civil Rights Act of 1965, that will change because they say that the Commerce Clause allows them to do that because segregation in like restaurants and businesses impacts interstate commerce, and that's kind of how they got around that. But in 1875, they didn't have that reasoning, so that was just unconstitutional. And what that ruling kind of did was open the door for Jim Crow and all of these other segregation laws that existed in the South, this de jure legal segregation. So they had all those. You learned about those in U.S. history, so you probably remember that. All the typical white and black drinking fountains and bathrooms and restaurants and stuff like that. In terms of voting, the voting restrictions were particularly potent in the South and really restricted the rights of black men to vote, which they got from the 15th Amendment. So the main ones that they used were poll taxes, which basically said that you had to pay a fee to vote, a tax to vote, which was particularly discriminatory because at that time, especially immediately following the Civil War, most freed blacks were not able to pay that. They were freed slaves, many of them were sharecropping, and they just didn't have the money to pay poll taxes. So this targeted specifically poor people, and African Americans at that time tended to be much poorer than their white counterparts just because of the economic disenfranchisement of them. Then the next one was literacy tests, which were reading tests that you had to pass in order to vote, which, again, were problematic because of the lack of a strong education infrastructure for African Americans, specifically freed slaves. It was in fact illegal for somebody to teach a slave how to read or write. So they were coming from that with really no basis for it. So it was discriminatory in that way, but then also the literacy tests themselves would be totally rigged because even if they weren't, impossible, which many of them were, the people that were grading them and judging them were white racist people who would pass all the white people and fail all the black people. So it was basically making it impossible for any black person to be able to vote. The last one was the grandfather clause, which wasn't something that was a restriction on voting, but it just said that voting restrictions don't apply to you if your grandfather could vote, because there were a lot of poor white people and there were a lot of illiterate white people, and that would have normally disenfranchised them. But the grandfather clause said if your grandfather could vote, then you could vote. And actually, it said in most of them, it said if your grandfather was eligible to vote, not even if they were registered or did vote. Now, obviously, if you are black in the South following the Civil War, your grandfather could not vote. So that made it impossible for this to apply to any black people, but it applied to all white people because all white men at that time were eligible to vote. So that's the way that they systematically disenfranchised African Americans in this period from Reconstruction up into the 60s. And this is just an example of a literacy test. And you could see just from looking at these questions, and there were more of them, that it's totally absurd. Like, number one, draw a line around the number or letter of the sentence. Like, what does that even mean? Like, how could you possibly answer this? And really, the reason for this, the reason they made it like this, is because a lot of these answers are subjective. There could be several answers to that prompt. And if you were white, no matter what you put, you were going to be right. And if you're black, no matter what you put, you were going to be wrong. They would just say like, oh, well, we met the other possible answer to that. And they purposely made it vague like this. And this isn't necessarily even a test of literacy. This is just a test of, again, race. And other literacy tests were very, very difficult constitutional questions. Like that was another type of them. And those, it would just be literally impossible to pass. Like, I used to give those in class to my students when I taught American government, and I always pretended that it was a quiz because it was impossible to pass. Impossible to pass. Most Americans today would fail it. Even the citizenship test that they give today in America, some people say that's kind of hard. This was like 10 times harder than that. It was very, very specific. I'll give you an example of it in class so you can kind of just see how ridiculous it was to expect that anybody would pass this. And again, if you're white, you didn't really have to pass it because of the grandfather clause, but also because the person grading it was just going to pass you anyway. Another important case, actually probably the most important case following the Civil War that dealt with this issue of equal protection until Brown v. Board of Education is Plessy versus Ferguson. So in Plessy v. Ferguson, this guy right here, Homer Plessy, he got on a train that was supposed to be segregated, and African Americans were supposed to ride in a separate car, and Homer Plessy, who was a black man, but he was like, I think 1/6 black, so he didn't even really look like the people, the ticket person didn't even know that he was black until he said to him, I am a black person and I'm going to go on this white only car. And he did that specifically because he was trying to get arrested so that he could challenge this in court. And they specifically chose somebody that was only 1/6 or whatever it was black, so that it would kind of just show how ridiculous this law was in the first place. So he gets on this train, he gets arrested. They challenge it in court to see whether or not this is a violation of the Equal Protection Clause. And what the court rules in this is that it isn't, that it's not a violation because separate cars are fine as long as they're equal. They argue that the Equal Protection Clause never says that things need to be desegregated. It just says that they need to be equal. And you could certainly have, segregated cars that are equal and segregated anything that's equal. So they established this policy of separate but equal. That is going to be the basis for the segregation laws and the Jim Crow laws that happen in the South. And then the next important case, which you need to know, Plessy isn't a required case, but this one is Brown versus Board of Education, which we talked about already. And it essentially overturns Plessy. It doesn't technically overturn it because it doesn't say that all segregation is unconstitutional. It's dealing specifically with schools, and it says that in schools, separate cannot be equal, and it's inherently discriminatory. And it even goes into the psychological aspect of it, like students in segregated schools feel psychologically inferior and they have to deal with this their whole lives. It also said that it was bad for the students in the white schools, and it overall was just not appropriate. So this is the first chip in Plessy, and then from there it's kind of just like all the other aspects of it get hit through different cases, and eventually it has to go away entirely. But this is the case that's most known for kind of ending this separate but equal policy. The problem with Brown versus Board of Education is that they never actually said, they said that you can't have segregated schools and that you needed to desegregate, but it never really said like when or how to do that. So then they had to kind of hear it again and just kind of issue a second ruling where they said that schools needed to desegregate with all due and deliberate speed, which, isn't like super helpful also, but it's at least a little bit better, gave some direction for how to do this. It did ultimately take the government forcing schools to desegregate because they didn't really want to do that. And, for the South, it kind of understandably took them a while to do it because, the court didn't really want to just say, okay, now you have 1 month, everyone must be desegregated. They knew that would be chaotic and maybe even cause violence. So they wanted to give a little bit of a buffer, but, eventually they had to just kind of say, okay, now you actually have to do it because you've been dragging your feet for too long. So Brown versus Board of Education is that anti-separate but equal case, and it ends segregation in schools and then eventually throughout the country. The Civil Rights Act of 1964 does a lot of things that the Civil Rights Act of 1875 tried to do and failed to do, but this one actually gets upheld in court. So this was filibustered by Southerners. Eventually they got cloture and they ended the filibuster after 83 days. This ends Jim Crow in places of any public accommodation. It prohibits discrimination in employment. It authorizes the government, the Department of Justice, to initiate lawsuits to start desegregating public schools and public facilities. It makes it illegal to, discriminate in employment based on race, religion, gender, all sorts of things. So this was kind of a step forward, a big step forward for civil rights. Eventually, this does get challenged in court, just like the other one did, but they said that because of the Interstate Commerce Clause, the Congress was allowed to do this. So this was, based on the Equal Protection Clause, but eventually it's the Interstate Commerce Clause that upholds it. So this is a video about the Civil Rights Act. It's going to go through all the different parts of it and explain it and how it was passed. Go watch this video. Either now, you pause it and then go watch it now, or you can watch this whole video first and then come back and watch this video, but you must go watch this video. It is part of the PowerPoint, and it is going to be part of your quiz, or it could be part of your quiz next class. I will also put a link to this video in the description of the video you're watching so that it makes it even easier. You don't even have to go and open up the PowerPoint for it. So the 24th Amendment basically just bans poll taxes. It makes poll taxes unconstitutional in the whole country. And this was aimed, obviously, at stopping the racist practice of the South. Today, this is kind of coming back into the political spectrum because of voter IDs, where states are passing these laws that you have to have a voter ID or some ID, like a license or something like that, to be able to vote. The problem is that licenses cost money, and if you're going to require some kind of ID that costs money, that would technically be a poll tax, because you cannot charge somebody any kind of fee to vote. States have gotten around this by saying that if they do have a poll ID and you don't have an appropriate ID like a license or a passport or something like that, then you can go to a government office and they will issue you a free voting ID. That's how they've been able to get around that, but that's briefly how it was in the news because of voter IDs. The Voting Rights Act of 1965 was focused on voting rights and making sure that historically disadvantaged communities were able to, participate freely in the voting process. So this outlawed literacy tests, grandfather clauses, other kind of discriminatory practices. It created federal oversight in voter registration in places that are historically discriminatory, mostly in the South. So basically making sure that they were not going to be racist and prejudiced when dealing with voter registration. Usually the federal government is not really allowed to interfere with elections. The states get to run elections, but in this case, the federal government basically just said, you've shown that you're so bad at this and so racist, we're just going to oversee it until you can prove that you can actually run your own elections again. That recently has started to cede back control to the states, because they felt like now the states are better at not doing that. So that very recently happened. It also increased voter registration in Black communities, largely because they allowed the federal government to do that. And that was a big step forward for civil rights in America. So affirmative action is a pretty controversial topic today. And the actual definition of it is it's a policy or program that provides advantages for people of a minority group who are seen to have traditionally been discriminated against, with the aim of creating a more egalitarian society through preferential access to education, employment, healthcare, social welfare, etc. So basically trying to even the playing field, provide advantages to people that are typically disadvantaged and discriminated against in areas like school or hiring and stuff like that. So the first time this is dealt with in any significant way is in the case University of California v. Bakke. And this isn't one of your required cases, but I do want to talk about it just because of its connection to affirmative action, and so it can kind of explain a little bit about how affirmative action is dealt with and how the courts have dealt with it and what the rules are for it. So in this case, this guy, Alan Bakke, was applying for medical school at the University of California, and he was rejected. And they have a special program, or had a special admissions program, where they had the regular population, everybody would apply, including all minority candidates, everybody would apply, and they had a hard GPA cutoff, and everybody below that was automatically rejected, and then they would just take the best candidates. Then they had a special admission program that you could apply to if you were part of a historically disenfranchised group, and that could also, or disadvantaged group, and that could also include like economic, areas as well. But this program, they just kind of took the top however many kids. I don't remember how many students it was, but they just took the top ones, and it didn't matter if they fell below the usual GPA threshold. So this was a program that can only be accessed by certain people, and that's kind of what Bakke was suing on. And he was suing on a 14th Amendment clause, saying that he was being discriminated against, he was being denied equal protection because he was white, and he was rejected because he didn't qualify for this program, and people might have gotten into the school that were less qualified than him, except that they happened to fit the racial or ethnic background of this program. So the court rules in favor of Bakke, and they say that you can, now while affirmative action is something that can exist, they say that it certainly can exist, and the goals of it are fine. They say that it's totally legitimate to want to have more diversity in your school. The University of California said that they wanted to provide more, get more doctors in historically, economically disadvantaged areas, thinking that people, from these areas would go to school through this program and then go back and be doctors in the community. And they were like, that's all fine. It's just that there's no evidence that this actually accomplished any of those goals. And they basically just say that a quota system is not allowed. A quota system meaning like this many students have to be from this, racial group. You can't do that. Race can be a factor. It could be a positive, but it can't be a negative, and it also can't. You can't have any spots that are open to some students but not all students. And that's essentially what Bakke says. So it confirms that affirmative action is fine if it's done properly, and a quota system is not an example of it being done properly. Shaw v. Reno is another equal protection case you need to know. We've talked about this a lot, so I'm not really going to dwell on it. I'll leave this here. You can pause the screen and look at it if you want and go over it, but we've talked about this plenty. So this is the facts of the case, and this is the question and the conclusion, basically just saying you cannot gerrymander based on race. So we'll end this there, and you can pause it and read it over if you want. So the next important group with civil rights is women, and women's rights have happened in a variety of ways and been progressed in a variety of ways, but they took a little bit longer in some cases. So for example, voting rights, women get the right to vote with the 19th Amendment, which happens in 1920. It's ratified in 1920. So, well after, Black men got the right to vote, women had to wait a bit longer. There's an Equal Rights Amendment that was championed by Alice Paul in the 20s, who was also instrumental in getting the 19th Amendment ratified. And this did pass Congress. It was never ratified by the states. Some states actually just are still voting on it, even though in the amendment it says like it expired. Basically they said it needs to be ratified by the state, and it wasn't. But it's unclear whether a constitutional amendment actually can expire. That's never really been a thing before. So that's still kind of out there, and I think they need like one more state to ratify it for it to become the law. Most states at this point are doing it just because everything in the Equal Rights Amendment is already kind of accounted for somewhere else in the law, but this would just make it constitutionally granted. But regardless, that's the Equal Rights Amendment. Family Medical Leave Act was passed in 1993, and that guarantees 12 weeks of unpaid leave after giving birth, and fathers can also take this. So this allows people to, keep their jobs if they have a child. They don't need to leave their job just because they had a kid. And in Title IX, it's Title IX of the Civil Rights Act, and this prohibits discrimination based on sex for federally funded programs. It's usually used for sports in schools, like public schools. That's like the most common time you'll see this talked about, saying basically that girls and boys sports need to be funded equally, or at least they need to be given the same opportunities. So if there's going to be a sport that's all men, so like football, for example, they can either have a girls football team or they can allow girls to play football. But they're not allowed to have a team and ban or bar girls from participating in it. So that's essentially what Title IX means. Like they have to have the same opportunities in federally funded programs, men and women. The Lilly Ledbetter Fair Pay Act of 2009, I believe, is actually the first law that Obama signed, and this is dealing with this wage gap, this idea that women and men get paid for different jobs sometimes. So what this does, this law allows an employee to seek damages or sue for damages for wage discrimination each time a discriminatory compensation practice occurs. So like every time that they get paid less, they get to sue, or that gets to be part of the lawsuit, which makes it, much, much harder for businesses to discriminate that way, because, they're going to be sued so many different times. It's going to be, a disaster for them. So that's the idea of this, to try to chip away and make sure that that wage gap doesn't exist anymore. Today, the bigger issue with the wage gap isn't necessarily like two people at the same company doing the exact same job and making less money, although that certainly still happens. The bigger problem is just the the big difference in wages for professions that are historically or predominantly women versus predominantly men. But this is still an issue that we're dealing with, but that's what the Lilly Ledbetter Fair Pay Act was meant to address. And lastly, the Americans with Disabilities Act, another big Equal Protection Clause law. This was passed in 1990, and it said that employers must provide reasonable accommodations for any disabled people, that it prohibits employment discrimination based on disability, and it also provides access or guarantees access to transportation and public accommodations. So like ramps into public buildings, stuff like that. This is also an example of an unfunded mandate, if you remember that from earlier in the year. The government passed this law, said that states need to comply with it, like build ramps and do things to make things handicap accessible. And the federal government provided no money for that. They said, here's the thing, you have to do it, do it. And that's an example of an unfunded mandate. So that's what the Americans with Disabilities Act was all about. So that's the end of this PowerPoint on civil rights. So next class, I want to talk a bit about this idea of civil rights. How are we doing with that in America? How far have we come with this? There's a bunch of other groups now that are dealing with these civil rights cases, like the LGBT community. So where do we go from here? Like, what are the parts of our society that are still working towards equal rights, and has this been successful? And I'd also like to talk a bit about affirmative action, which I know is a case that thing we've talked about in the past already in class, but I want to talk about it a bit again, just to kind of see your thoughts on that. You're all going to be going to college soon, and this will potentially impact you. So I want to see your thoughts on this whole process. So that's what we'll talk about in class next time. If you have any questions, write them down and we'll discuss them in class.